Hello and welcome viewers. You're watching In Depth with your host Kriti Mishra, a platform where we break the most complex issues of the world and our country in just 5 simple questions and their 5 simple answers and help you understand how these issues matter to you. The Supreme Court has said doubling the number of judges was not the solution for pendency of cases. So what did the top court say? Well, a bench of Chief Justice D.Y. Chandrachud and Justice P.S. Narasimha refused to entertain a PIL filed by Advocate Ashwini Kumar Upadhyay for doubling the number of judges, saying he has adopted a very simplistic approach. Upadhyay said that nearly 5 crore cases are pending in courts, which means nearly 20 crore people are impacted, and this is close to the population of the US. The Supreme Court said doubling the number of judges was not the solution for pendency of cases, as more judges does not really mean more case disposal, and instead, good judges are required. So what are the reasons of pendency of cases in India? Well, between 2010 and 20, pendency across all courts grew by 2.8% annually. As of September 15, 2021, over 4.5 crore cases were pending across all courts in India. Of these, 87.6% cases were pending in subordinate courts and 12.3% in high courts. At present, there are 14.7 judges per million population in the country. Generally, high courts and subordinate courts that serve a larger population have a high number of pending cases. District courts across the country also suffer from inadequate infrastructure and poor working conditions, which need drastic improvement, particularly if they are to meet the digital expectations raised by the higher judiciary. As per the current constitutional scheme, English is the official language for the Supreme Court and the High Court until Parliament by law otherwise provides. For those coming from different linguistic backgrounds, the complexity of statutory language makes the legal system difficult to understand. This language barrier limits the understanding regarding their rights. There was a drop in new cases as courts went digital, but with lockdown restrictions in place, a slower disposal rate resulted in more pending cases. So what are the initiatives taken by the government to reduce pendency? Well, the centrally sponsored scheme for the development of infrastructure facilities for judiciary has been extended till 2025-26 at a total cost of 9,000 crore. Out of which, central share will be more than 5,307 crore. Government has been implementing the e-Courts Mission Mode project throughout the country for information and communication technology enablement of district and subordinate courts. Number of computerized district and subordinate courts has increased to 18,735. 44 judges were appointed in the Supreme Court. 710 new judges were appointed and 588 additional judges were made permanent in the high courts. Sanction strength of judges of high courts has increased from 906 in May 2014 to 1,104 currently. Amendment to the Arbitration and Conciliation Act 1996 has been made by the Arbitration and Conciliation Amendment Act 2015 for expediting the speedy resolution of disputes by prescribing timelines. As on 31st of January 2022, 915 fast-track courts are functional for heinous crimes, crimes against women and children. In addition, to reduce pendency and unclogging of the courts, the government has recently amended various laws like the Negotiable Instruments Act of 2018, the Commercial Courts Act of 2018, the Specific Relief Amendment Act of 2018, the Arbitration and Conciliation Amendment Act of 2019, and the Criminal Laws Amendment Act of 2018. Well, what is the alternative dispute resolution mechanism that everybody is talking about? Well, ADR is a mechanism of dispute resolution that is non-adversarial. That is, working together cooperatively to reach the best resolution for everyone. ADR can be instrumental in reducing the burden of litigation on courts while delivering a well-rounded and satisfying experience for the parties involved. The resolution of disputes takes place usually in private, helping maintain confidentiality. It is more viable, economic, and efficient. Procedural flexibility saves valuable time and money and absence of stress of a conventional trial. So what is the way forward? Well, one of the solutions is to substantially increase the strength of the judicial services by appointing more judges at the subordinate level. Improvements must start from the bottom of the pyramid. The Supreme Court may mandate summary disposal of all hibernating PILs, those pending for more than 10 years before high courts, if they do not concern a question of significant public policy or law. The appointments and improvements will require significant but absolutely necessary expenditure. Well, with that thought, let me sign off. Goodbye from my side for now.